Hi, Nick Dogan, or State Law. We safeguard your professional license so you can get back to business. Today, we're going to talk about what to do when you first receive a complaint from a state agency or licensing board. So, rule number one, when you're dealing with any sort of allegations against your license, and whether that is your individual professional license or your business's license, your facility license, whatever the case may be. Say you own a daycare and you get an allegation against your facility. So, or any sort of profession, you get an allegation that comes from your licensing and over to you. Rule number one with that is thou shalt not ignore your licensing board. There's a lot of reasons why, and the one that I'm going to lead off with seems really silly and kind of dumb, to be honest with you. But frankly, it is what it is, and I'm being 100% serious because I've seen it a million times. But ignoring when a licensing entity reaches out to you, whether that's your state board or your state agency, whatever the case may be, ignoring them, frankly, just upsets them. It makes them mad. It pisses them off. And the reason being is they feel like you're not taking it seriously, and that maybe they feel like if they're being ignored, then their authority is being ignored as well. And that really upsets them. That in and of itself could be a violation as well, because some of these boards and agencies, they have it in their administrative code and or their statutes that you have to cooperate. Some have like full cooperation in there. Some, like the medical board, say if we request a written response, then you are to provide that written response within X amount of time. Also, like medical board also has, if an investigator reaches out to you to do an interview, then you have to comply, and you have to comply within the certain time frame. So if you ignore either one of those or both, then that in and of itself is a violation. So you'd be looking at defending a violation from the initial complaint that was made by whomever, and then you also got to defend the complaint for ignoring them for the complaint that was originally filed. So now you've upset them, and then now you've potentially got another violation on top of the original violation or violations. So you've compounded the problem multiple ways. So it's very important, extremely important, to start off on the right foot in your case if you get a notice of a complaint of a license violation. So another thing that you have to be aware of too is, on the flip side to all of this, you can't really rush into stuff and say, all right, I'm going to give them everything, because you may not exactly know what the complaint is about. I've seen that a million times. It is very common for a licensee to get a complaint and go, yeah, I don't really know much about what's going on. A lot of the times, and the General Contractors Board does this a good bit, where their complaint, especially at the very, very beginning, is pretty bare bones. It's like, complaint was submitted to us on such and such date, and it is alleged that you have violated this statute and or this code. So at least you get a little bit in there, because you can look up the statute and the code, and it'll kind of tell you, vaguely what the allegation would be about. But factually, there's usually not a ton of facts in there, and you can kind of, you might be able to figure it out and say, all right, well, I had this client, 3 or 4 weeks ago. They were being difficult to deal with. I kind of saw this coming, and you probably have a pretty good idea of what's going on. Other times, it'd be like, everything was going pretty good. I don't know who would have filed a complaint against us. And it might be a competitor. It might be somebody at the planning department. It might be, somebody else, some random person. Sometimes it's an honest mistake, and it doesn't happen often, but sometimes people make a complaint against somebody and they get confused. But that's why it's important not to offer up a bunch of information, just as important as it is to not ignore these licensing complaints, right? So it's a fine line that you have to toe between, yes, I want to comply. I want to make sure that the other side hears my side of the story, because that's the other thing. Like, if you don't provide any information, and say you're not even required to provide any information, A, you're still going to upset them. And then B, if you don't provide any information, then they've only heard one side of the story and it's not yours, right? So you want to, at the very least, acknowledge from the get go, hi, I received your complaint. Um, I am working on a response, or I'd like to, get provided more information as it becomes available, because I don't know exactly what's going on here, and I don't want to misrepresent something that may or may not be true, or may not be relevant to this allegation that I'm not fully aware of what it contains. So we've also seen people offer way too much information, and they've put themselves in a very bad situation further along in their case. So we've had numerous people over the years that have come to us, like 3 or 4 months into a complaint. They thought they could do it themselves, and I don't blame anybody for trying to do anything themselves. We deal with a lot of highly intelligent individuals. I mean, people that are licensed professionals typically have a lot of school behind them, a lot of college education, usually at least a master's degree, if not a doctorate. And rightfully so, they feel like, well, I can just handle this myself. I don't need an attorney. I'm really smart. And you are. But you've never handled something like this, and you're representing yourself on something that, if it goes sideways, then you've just torpedoed your livelihood. So we've seen it a lot of times where we get hired a little bit later in the process, and then we have to play catch up, and we have to kind of scramble and undo a couple of the things that were done wrong at the beginning of the process by the client. And you got to be really careful, because one little sentence in a written response, or one statement to an investigator that is taken out of context, can really put you behind the 8 ball later on in your case. And you might be looking at severe penalties, whereas had you taken your time, formulated a very detailed, but not overly, not offering too much information, but not offering, too little information, just that right amount. You get just the right amount of detail in there, but not too much. And you do that, and maybe you put yourself, not maybe, but you do put yourself in a much better situation going forward. The other thing is, a lot of these boards and agencies, they play a bit of an information game. We live in an information age, have for a long time, and information is king and queen. And so they know that. So they don't give a lot of information until they actually have to. So on the flip side, even if you're required to provide information, just provide enough to where you're in compliance with the statutes and/or codes, for cooperation. You don't want to over offer information. You don't want to under offer information. You can always offer more things later on in your case, as you learn more about the allegations, like who did it, what evidence that they may have or maybe they don't have, or things like that. And also, you want to get your ducks in a row. You want to make sure that, hey, let me go back through my records. Let me see what we're looking at here, because it could be a situation where, what, I made a mistake, I messed up, and here's what I've done to correct that. And you don't want to jump right in, like jumping off the diving board head first into a 2 foot 2 foot pool. Obviously, that's going to hurt. So similarly here, you don't want to jump right in and just, here's everything that I got. You can take your time, as long as it's done within whatever designated time frame is given to you by your licensing entity. And you can package it in a way to say, like, all right, I made a mistake. Here's what I did to correct it. Here's, any sort of letters of support for me, showing that I've never had a problem like this before, wherever the case may be. On the flip side, if you've got a lot of info that says, I didn't do anything wrong, here's my proof, you don't want to jump into that 2-foot pool right away, because presentation does help. It helps a lot. And if you're able to present evidence in a manner that the light bulb is going to click right away with whomever's making the decision and with your licensing entity, then it's going to help lessen the process and help expedite a dismissal if that's likely to be the outcome, right? Because the sooner you can nip it in the bud and get the complaint to go away and not be brought up again, then the better off you are. That's less time that you spent, probably less money you've spent, and it's going to be better for you all the way around. So I hope that was helpful, and please do not violate the first rule, which is thou shalt not ignore your licensing board. If you got any questions on anything, then please give my office a call. You can call or text the following number. That's 919-521-8810. You can get a free 15-minute discovery call. Before you do any of that, please check out the blogs on northstatelawfirm.com is the website. North State Law is the YouTube channel for a lot of other videos on there as well. And thank you so much for watching. Hope to see you again. Bye-bye.